So what are minded to letters? For the eagle-eyed amongst you, you might have seen a video popped up on the channel a couple of weeks ago which basically set to explain this, and I got some helpful feedback in the comments and a few other places as well, which essentially said the suggested course of action I included in the video could be a criminal offence to do that. So obviously kind of took the video down, had a look at things, went back through some textbooks, and essentially just wanted to work out what the law actually was. There was a reason why I thought it was legal. I'll explain that a little bit later, but when you actually look at the detail, potentially it would not be. I'm not 100% sure it's a criminal offence what I was suggesting, but it would appear to definitely be an abusive process. So let me explain what the process is, and then I'll explain what I was suggesting and then why that might be a criminal offence. So in short, minded to letters are draft decisions that are there to give people the opportunity to provide more information, argue a particular point, correct something that's wrong, effectively to increase the chance of that decision actually being right the first time. And the only place in the process a council has to issue a minded to letter is actually quite a long way down the process. Once a negative decision has been issued at the section 184 stage, the person's then requested a review, and so before that final review decision is made, a minded to letter should be issued, which, as I say, is basically a draft decision, and it will then give the applicant maybe 7 or 10 days to provide further information at that point. However, councils always can use it earlier in the process, and I guess it just might be helpful just to highlight what this process is to understand where it can also be inserted into it. So you make a homeless application to any department of a local housing authority by asking for help with housing and giving them reason to believe that you might be homeless or you might be threatened with homelessness. That triggers section 184. A number of other duties that can then arise. So for example, the duty to provide emergency accommodation where there is reason to believe the applicant might be homeless, might be eligible, might have a priority need. There would be potentially the relief duty kicking in if the person's already homeless, or the prevention duty might kick in if they're threatened with homelessness. There would be potentially duties around protection of property, and just general the requirement to provide competent advice as well during that process. So the relief period ends for at least 56 days, and the council is then likely to issue a final section 184 decision on day 57. There's a few caveats with that as always, but basically if you're owed the main duty, then you have to be issued it on day 57 unless there's particular complexity, in which case there's another 3 weeks. And in most cases, even where the person's not owed the main duty, most councils will issue the final decision. So really it's incredible if a housing officer actually managed to follow every single bit of the law in that process. So you might wonder, well, why on earth would they do an additional letter in that section 184 stage? This are absolutely correct to say that the existing duties, the way the relief duty works, the way the HRA, the Homelessness Reduction Act works in general, is incredibly onerous. So really it's incredible if a housing officer actually managed to follow every single bit of the law in that process. So you might wonder, well, why on earth would they do an additional letter in that section 184 stage? And effectively the answer is to hopefully avoid having a duty to house that person. I might sound a little bit clumsy how I've put that, but that's effectively what it is. So when the final section 184 decision is made, and it has to be made in writing obviously, there'll be instructions within that letter of how to challenge that decision. I'm not going to use the word appeal because appeal actually comes a lot later in this process. Appeal has particular connotations in the homeless application process. So at this stage we're not appealing it, we're challenging it, and we're challenging it through the review process. So effectively we're asking the council to review their decision to work out if it's correct or not. But councils don't have a duty to house someone whilst that review takes place. Now bear in mind, you might actually be in priority need, you actually might be vulnerable, and that initial negative decision is nonsense, it's perverse, and so there is no duty to house you whilst that review takes place. But there is a power to, and case law, I think it was Mohammed v Camden, essentially set out some criteria which council should adhere to when they're working out should they house someone during that review process. And effectively it's kind of based on how strong the argument is that you're advancing in the review request. It would also take into account things like, would you be left street homeless or would you be left destitute if they didn't house you, that kind of thing. And there's also this idea of whether you are providing new information at that stage. There's some other bits as well, but I don't want to overcomplicate the video. So it's in the council's interest, if they are knowingly going to issue a perverse negative decision, as in one they know full well is not correct, that to avoid the chance of them having to house that person down the line, they need to make sure that they've dotted all the I's and crossed all the T's in that section 184 notification. And part of that is going to be to make sure they have taken into account every single relevant bit of information they can do which you'll often see listed in these decisions, so that you can't then have any new information to raise at that review stage. Now, things might change anyway naturally, that they could lead to new information, but that would be the way it would work. And the reason I'm so cynical is how many perverse Section 184 letters I've seen, where effectively the housing officer just pays lip service to the duties that they're owed. And lip service is essentially when the council officer says, I've carefully considered your circumstances, when in reality they've done anything but. They haven't carefully considered anything at all, but they're just using these template letters that they get given. And effectively the template letters will have like boxes that they have to insert information into. One of the boxes will be list all the relevant information. So it'll be things like GP letters, psychiatrist reports, OT reports, those sorts of things. And if the housing officer can basically list all of those things in that perverse decision, then it safeguards them. It reduces the chance of you being able to then get accommodated whilst the review takes place. And obviously this makes a lot of difference to people at that stage. I'll give you one example of many I've seen. This is actually a slightly different issue here, because often these non-priority decisions will be spread over many pages, so it's actually quite difficult to have a little bit that I can show in a video to kind of illustrate the point. But this is from a Section 184 decision, and councils also have to carefully consider whether the person has a disability for various reasons. So here's an excerpt from one a few years ago, where the housing officer says, you told me you've been diagnosed with fibromyalgia, osteoarthritis in your feet, knees, hips and shoulders, and PTSD. You advised that you're prescribed gabapentin 3 grams, morphine sulfate 60 milligrams, venlafaxine 225 milligrams, and paracetamol 4 grams a day, essentially. And then the housing officer goes on to say, having taken account of all these conditions, I have reached the conclusion that I do not consider that you are under any disability. Now, anyone who knows anything about disability law knows that you make that assessment based on what would happen to the person if they didn't receive their treatment. So in this case, if you were to take all this person's medication away, what would be the likely outcome for them? And clearly, if you were to take someone who's got arthritis and fibro and PTSD, taking all their meds off them, it's very likely that there's going to be an impairment that develops that's going to have substantial impact on their day-to-day living activities. So this is an example where somebody very clearly has a disability is essentially ignored in this regard, and the housing officer just resorts to these template wording to show that they supposedly have taken it into account when, as I say, they haven't. So you can see a lot of non-priority decisions that you'll challenge over the course of your career if you're into this sort of thing. You'll basically have various bits of information laid out in the letter, but they won't deal with them properly, they won't give them the proper weight, they'll ignore certain bits, they'll basically include things which are not relevant at all into their decision making. So there's often ways in which you can challenge it, but the most straightforward way to challenge it is generally going to be to provide new information they didn't include. And so in the video I took down from the channel, essentially the suggestion I had was keep one bit of information up your sleeve, so that if they are to put out a negative decision, you can whip out this other bit of information, and essentially that would lead to a likelihood that there will be a power to accommodate you pending the outcome of the Section 202 review, or in theory I guess to allow you to actually trigger a fresh application down the line with this new bit of information. So the question then is, okay, is it a criminal offence? So as I say, I'm hoping I've answered the first part of the video, which is what is a minded to letter. It's a draft decision which gives you the opportunity to essentially kind of give additional input. It has to be done before the Section 202 final decision is made. It doesn't have to be done before the Section 184 decision is made, but often it will be. And cynically, I would say it's because councils want to reduce the chance of them having to house you down the line, even when they issue a perverse decision. So we then need to tackle this question of, is it a criminal offence to knowingly keep back a bit of information that's in your favour so that you can then pop it out down the line in order to increase the chance of you getting housed whilst that review takes place? And Section 214 of the Housing Act 1996 basically lays out the criminal offences associated with this part of the Housing Act, so the homeless application process. And basically there's 3 subcategories, 2 of which I don't think apply, but the third one potentially does. So if we go to the first one, which is making a false statement, effectively this is designed to stop people providing false information in order to make the council think that they're either in priority need or they're not intentionally homeless. And I'm getting most of what I'm about to talk about from Homelessness and Allocations, which is this good textbook here. It's from Legal Action Group, which are great. I don't know what the latest edition is. This is the 11th edition, but this remains similar for various editions that go back. So in that textbook, it actually specifies that we're only here talking about priority need and intentional homelessness issues. And I don't know why that is. It just seems to insert it into the textbook. The textbook's written by a very, very learned team of people. So I'm going to take that as being, kind of good indicator of what the law actually is. But as I say, it's interesting that it only applies to priority need and intentional homelessness decisions. Now, to give you an obvious example of this, let's say I made a homeless application and I was with my wife and I told the council my wife was pregnant when I knew full well she wasn't. And I did that in order to make the council think I was in priority need. That would be an example of where providing false information would be a criminal offence within the Housing Act, and I could be prosecuted. I think you can get up to like £5,000 fine. You'll probably also get banned from the housing registry and stuff like that as well, but that would depend on the local policy. So that's obviously, I don't think that's a surprise that would be a criminal offence. That's not okay to do. We've then got the second bit, which is withholding information. This is where it gets a bit more interesting. So let's say I made a homeless application and my wife genuinely was pregnant, so they accept us into interim accommodation, emergency accommodation. But during the next couple of months whilst I'm under relief duty, my wife leaves me and she moves back in with her family or something, and so she is no longer part of my household. So there is no longer a pregnant person in my household. I've got no other vulnerabilities. I am not actually in priority need at that point. But because I don't want the council to issue a negative decision, I don't tell them that my wife has moved out, and therefore they, might mistakenly reach a conclusion that I am actually owed a main duty when really I'm not. So that would be an example of where this withholding information would be a criminal offence. But again, there's some small print in the textbook which essentially says, and I'll read it out here, so accordingly, this criminal offence is directed at a person withholding information that would be harmful to an applicant rather than at someone who refuses to provide helpful information. So in the video I made about this before, when I suggested that people hold back a bit of information, that doesn't appear to come under this part of the Housing Act, as in it's not a criminal offence, because it's not a piece of information that would harm you, it's a bit of information that would help. Now additionally, just to say about these first two criteria is, they can be committed by anyone. It doesn't just have to be the homeless applicant themselves. So if you're an advisor or an advocate or something and you lie to get the council to accept a duty to house someone, that is a criminal offence, assuming you've done it specifically to induce the housing authority to believe that the duty is owed when there really isn't one. It'd be a criminal offence. And again, I don't think that would be that surprising, but I think this is what I must have read several years ago, where I thought actually it would be legitimate to keep a bit of information back that's in the person's favour, so that should the council make a negative decision, you can then pop it out there. It would be new information, and it would mean it was likely that council would then have to house that person whilst the review takes place, or enable them to make a fresh application altogether. There is, however, a third part of this criminal offence which I had not been aware of, and this is where it gets a little bit tricky. So the third part is essentially failure to notify changes, and with all of these things it's important that councils find a way to communicate these criminal offences to the applicant in a way which is not intimidating. So actually I think 18.10 of the Code of Guidance says it. I'll put it up on the screen. That's quite difficult for housing officers to do, because if you're a homeless applicant, pretty much everything's intimidating. You go to a council office, into a private interview room, you've probably never done it before. It's all very new. And the first thing the housing officer says to you is, oh yeah, by the way, if you tell us something wrong, we're going to prosecute you. Obviously that's quite a bad way of saying it. Obviously you'd have to say it like that, but even if you try and kind of pad it a little bit, it's quite difficult to articulate that in a short space of time. But this failure to notify changes is quite similar to the idea of withholding information. So in the circumstance where my pregnant wife has left me, that is a material change. That is a relevant change of facts which the council need to know about, because it's going to have an impact on the decision that they're going to make about me. And interestingly, this offence can only be committed by the applicant rather than the advocate or a landlord or a family member or something like that. And I'm going to read it all out because I guess I can't do justice to it without doing that. And it basically says, an applicant is under a positive duty to inform the authority as soon as possible of any change of facts material to his or her application. So material just means relevant, which occurs before the receipt of the notification under section 184 of his decision on his or her application. So before that section 184 duty. And so this would cover a lot of different things. As I say, in the course of the homeless application process, life is just generally going to mean that things will change. Kids get older, new babies are born, kids might leave home, you might have other things that happen, changes of income, all those kind of things that might be relevant to the housing authority's decision. And it seems that this suggestion that I've put forward, that people keep a bit of information back in order to pop it out later in the process, would essentially be a breach of this duty. Now, it does say within the textbook that this is quite an unexplored area of the law. There doesn't appear to be any case law on it, and effectively the benefit of the doubt should probably go to the applicant in this circumstance. So I think this potentially would mean that keeping a bit of information back deliberately in order to then submit it at a later date, it may well constitute failure to notify the authority of changes. But even if it isn't, there was an additional thing that came up in a case that we explored on Will Flack's live stream a couple of weeks ago, which was about this case Ivory versus Welling Hatfield. And essentially it was about whether someone can make a fresh application. And a similar issue had come up in that case where the solicitors had received a very detailed medical report and they had not initially made it known to the council, because by this stage it was already the Section 204 process. And essentially the council took umbrage to this. However, in that situation, that was kind of all good anyway, because essentially at that Section 204 stage, it's not usual for new information to be essentially submitted at that point. And so what happened was they didn't disclose this report they had, they waited for the negative decision, and then they used that new report to trigger a fresh application anyway. And as I say, the council didn't like that at all, but the judge basically said, in the circumstances, that's fine. But it did open up this possibility that that could have been an abusive process had the circumstances been different. And again, even if my suggestion of keeping a bit of information back is not a criminal offence, it potentially would be, or it probably would be, I think, an abusive process. So this really sticks in my throat to kind of say this, because I know how perverse decisions can be from councils. And in one sense, if you're a homeless applicant, the odds are stacked against you a lot of the time, because councils will issue perverse decisions knowingly. They will kind of abuse the process on their side, and there's no real accountability for that. But if you were to, as I say, play the game in that sense, as I suggested in that previous video, potentially you are going to be in a situation where they might start accusing you of breaking the law and committing a criminal offence. Now, the chance of actually being convicted is very, very low, I think, in reality, but they could certainly just basically stonewall you and say, we're not going to take any further application from you because you've abused the process, which is obviously not an ideal situation to be in. So, in terms of practically what I think you can do legitimately, I think even from the first assessment you have, and even from that first email you used to trigger the homeless application in the first place, you want to be basically really, really kind of liberal with information that's going to be relevant, that's going to help your case. So anything that's around in terms of doctor's reports, diagnoses, information from other professionals, that sort of thing, you want to submit that at that point. When it then gets to that stage where the council might issue a minded to letter before the Section 184 stage, I guess the answer has to be you have to provide anything else you've got. So if you've got additional medical reports, if you've got something else, you actually have to submit it at that point. So I'm hoping that is more accurate in terms of what my understanding of the law is. It's probably worth reiterating that this is definitely not legal advice. I'm not a lawyer. Effectively what I'm trying to do is just kind of help people put their own case forward and get good outcomes. But it's just an illustration of how some guy on YouTube may well tell you stuff which is wrong, which could actually get you into trouble sometimes. So if you watch that original video, do disregard it. Essentially take what I've said in this video to be more accurate. And again, even within this video, I think there's still some gaps in my knowledge of understanding how it all works. But in short, minded to letters are draft decisions that you can challenge. They don't have to be done at the Section 184 stage, but they might be. I would almost see that as a bit of a red flag, to be honest, if the council's doing that, but that's just me. You need to provide information when you're asked for it by the council, and you need to update them on change of circumstances. Obviously, you can't be lying about stuff, but I'm pretty sure most people watching the channel will know that already. So that's not the kind of not the main point of this video. But yeah, certainly this idea of when a council asks you for more information and you have it, then I don't see any way that you can withhold it legitimately.